It was explained that the first risk was the defendant's previous threats of hanging authority figures, including police, as threats of action that would fall within the definition of terrorist act. In section 100.12 of the code, but not subsection 3. These are threats of an action that would result in death, and are threats made first with the intention of advancing a political or ideological cause, and second with the intention of influencing the police or other public figures in the performance of their duties. It was argued that the defendant's continued adherence to these previously expressed beliefs indicates a real prospect of him resuming conduct of the kind engaged in prior to his arrest, and so there is significant likelihood of the defendant engaging in conduct that constitutes as a terrorist act, being an offence contrary to section 101.1 of the code. And this is where the police are totally shot down in a ball of flames, and they don't know where to go from here. They have tried to tar this brush so many times over and over, and it's demonstrated that this little squad inside the New South Wales Police Force has chosen to discredit the police force's name by attacking faithful Commonwealth civilians, people that are loyal to that constitution more than most people in society today. That's the irony here, is that there's some sort of loyalty in a line of authority which holds that constitution as a sacred garden of God. And for these officers to believe that they are in somewhat protecting either the garden or the children in the garden is a joke in these circumstances. 59. The first scenario was said to comprise the defendant continuing with the conduct of the kind engaged in prior to his arrest and incarceration, and the second, the risk of escalation of his conduct. The whole flipping this on the defendant is incredible, in that they have the gall to go about creating a task force and taking command of said task force to go after what would be considered a honourable and Christian organisation which would see to defend the Constitution of the Commonwealth of Australia, and then turning that into a terrorist act, and then somewhat trying to cover their tracks by imprisoning a man over what would normally be a toy gun, and then treating him in a manner so badly to have actually committed an international criminal offence under the International Humanitarian Law Rule 92 and Rule 90, to then actually demonstrate the opposite of what they're trying to pretend to defend. It's asinine is the answer. It is totally asinine, which is why they worry about creating a milieu which fosters this prospect of change, which would then threaten innocent members of the community, which is quite the opposite, in that it would be the police that would be reacting and creating the melee that would follow. This is the bait and switch being played by the police. Not wanting to cause harm, injury, or loss, I don't see how, as a united people who identify under a flag that could be construed to engage in any conduct that would go outside of the Constitution. That's just a flat out conundrum at law. 59. The first scenario is said to comprise the defendant continuing with the conduct of the kind engaged in prior to his arrest and incarceration, and the second, the risk of escalation of his conduct. 58. The written and oral submissions made on behalf of the plaintiff then descended into a level of complexity which it described as potential, open bracket, risk scenarios, close bracket. The complexity of these potential and in some ways speculative scenarios, to my mind, underscores the speculative and uncertain nature of the risk allegedly presented by the defendant that he will commit a serious terrorism offence. So we can see that the justice is aware that this initial incarceration and these claims are not relevant to the actions that are taken out by these doctors during this incarceration. We can see by all of the evidence stacked up together that the state has acted in a very irresponsible manner in wielding a power that it thought it had to use but didn't exist. And on the flip side, we've seen that these videos that they've relied on as evidence turn out to be a warning at law, in that there is a correct statement being made in that United Nations peacekeepers arrived and knocked on the door of New South Wales correctional facilities for a reason. 57. The plaintiff submitted, the state and the Crown prosecution submit, that they have concerns regarding mental health comprising of the nature of the defendant's mental illness, the poor history of compliance with medication, and his failure to comply with supervision by community corrections, as well as his lack of insight and impaired judgment. So the state, including the Crown Law Office, working on behalf of the Crown, are submitting that they have concerns regarding comprising of the nature of the defendant's beliefs, at which they have already been correcting with drugs and seek to further correct, at which it's proven now that this curial belief isn't so unbelievable. And that's a conundrum coming back up the document when this document was denied and these beliefs given some sort of credence in the knowledge that there is a line of authority that takes place within the state itself, and this becomes evident of the attack by state agents against a belief. And it's more a question than a belief, as we've already established. You answer the questions and the answer is what we can believe in.